I want to welcome everybody to the 10th annual McCarthy Symposium. Yay! And I am going to be very brief because we're already a few minutes behind, and my job for most of the day is going to be the clock Nazi, so you'll see me cutting people off along the way. But I am thrilled to be here and can't believe what a wonderful event this has become. David and I met in San Francisco in the Haight back in 2008 to just talk about a few issues when I was at Microsoft. We were facing a few tech-related issues that were causing some tension in the trademark space, and as we had the discussion, it evolved into a discussion around David saying, you know, there's so many issues you guys are facing, you really should start a symposium. I'll host it for you guys, and we can have a little debate about it. I said, okay, there's one condition for us to do this. I'll help you fill the room for a symposium if you get Tom McCarthy to speak. And he said, I can do that.
I can do that.
And from that day, we surprised ourselves, and we were in San Francisco and filled the room with students and practitioners, much like we're doing today. And we said, we have to do this again. And so we took it the next year up to Microsoft. The year after that, we took it to Time Warner up in Manhattan here. The next year, we're like, how do we top that? We go back to 20th Century Fox Studios in the studios in Hollywood. What next? We take it to London. We do it at the British Library. We add a second day there. Oxford was nice enough to co-sponsor that event, and we had a second day on the regulation of search, specifically in the Rhodes House at Oxford, so that was fantastic. At some point, though, we have to recall that this is about law school and students as well. Brought it back to San Francisco, where the Institute resides, and made sure that the students were back involved with it again. And from San Francisco, have since taken it up to Amazon in Seattle, taken it back down to Silicon Valley, where last year it was at Google, and this year we are thrilled to have it here at NYU. And I want to first thank David Franklin, my partner in crime, for helping get this all started and continuing this going. Second, I want to make sure I thank both Barton and Jeannie, the rockstar professors from NYU, who are the gracious hosts here for us today. And then, and most importantly, I want to thank Tom McCarthy, because without Tom, most of us wouldn't be trademark practitioners. He paved the way for all of us. And he's lent his name to this institute. And not only does he lend his name and the Institute's name for this symposium, he still comes and presents. So thank you very much, Tom. And with that, I'm going to turn it over to Jeannie.
Hi, everyone. Good morning. I just briefly wanted to welcome you to NYU. Thanks for coming here in the cold. It sounds like it would be nicer to be on the West Coast at some of those great locations right now. So thank you for being here. And thank you for bringing this terrific event to NYU. So on behalf of NYU and the Engelberg Center, we're just delighted to have this fantastic event here today. And I will turn things over to David Franklin.
Great, thank you. Well, hello, welcome. I'm the director of the McCarthy Institute, which has moved from University of San Francisco to Golden Gate University. And we have a lot of our Golden Gate University students here. Flew across the country to be here. We also have our deans of the School of Law, the School of Business. I was hoping they would stand up. Dean Nidwicki, are you in the room? Would you just say a few words of welcome?
Yeah, I just want to say thank you for hosting us here. I was saying last night, so I guess we needed some cold in our lives from California, so we had to come out to New York. But I also wanted just to highlight that we have almost 45 students that flew here from GGU, which shows and is a tribute to how excited we are to have the McCarthy Institute. So I just want to also publicly thank David Franklin and Tom McCarthy for bringing this to the school, because I think it really has become a transformative time for us.
Thank you, Dean. Dean Schwartz, would you say hi? This is Dean of the Business School at Golden Gate.
Hello, looking forward to some great collaboration between the business school and law school.
I hope I
Meeting with
don't
a few
step
people in
on
the
your
room
line
who's not
too
an
much.
attorney or aspiring attorney. I'm told to keep my mouth shut.
It won't hurt to
Really, I think it's a fantastic opportunity. Thank you so much for organizing it and getting it going.
people on
Thank you, Dean.
accumulate.
All right, now more thank yous. Real quickly, before we move into the substance. We have a lot of wonderful sponsors of this event, and their names and logos, trademarks, if you will, are on the slide behind me. I'll just tick them off real quickly. Many of these law firms and other entities have sponsored this event multiple years in a row. So we have Banner and Witkoff from Chicago, Debevoise and Plimpton from New York. The European Union Intellectual Property Office is co-sponsoring this. And I should mention that they also have invited us to come to Alicante, Spain, to their headquarters, and we're having a McCarthy Institute symposium with them on September 26th and September 27th of 2019 in Alicante. So it'll be on all kinds of issues related to global trademark practice, and we hope you can be there for that. Is Gordon and Zhao here in the room? Right here in the front, our delegation from Europe. Thank you for being here. All right, we also have Fish and Richardson and Hogan Lovells, INTA. I think this year the president and CEO were not able to be here, but we have a past CEO who I saw come in, Alan Drusen. Where is Alan Drusen? Alan, stand up, say hi. Alan was the first CEO of INTA that I met, and he got the McCarthy Institute involved with INTA, and really it's helped us take off in many ways. So thank you, Alan. It's great to see you again.
Thank you, Dave.
All right, take care. And we have Keystone Strategy Consulting. We have Perkins Coie, Seed IP, which is where Russ is, Unitalent, a huge Chinese IP boutique, which sponsors us every year, Shepherd Mullen, and we say thanks to the New York Intellectual Property Lawyers Association, which in addition to these other organizations was able to put out some advertising and email blast invites for us. So thank you. We give a round of applause to all of the sponsors who made this possible. Oh, I got one more. I don't know why they're not there. Bereskin and Parr. Should have been, where are my people? All right, Bereskin and Parr. We're going to make a special one for that. All right.
It is on the program.
Oh, it's on the, my back. All right, you're back.
All right. Thank you, David. To keep this moving, since we got a little bit of a late start, we're going to jump right in. I am thrilled, speaking of Bereskin and Parr, we're going to have Janice Bereskin as the moderator for our first panel. And we're going to be having the topic of when virtual meets real, brands from video games to fictional brands. And with that, Janice, please take it away.
Good morning. It's great to be here. Thanks, Russ. And on behalf of Bereskin and Parr, your friends in Canada, we're happy to sponsor this amazing symposium again this year. It's hard to believe that it's actually colder in Toronto than it is in here. This still feels cold, even to a Canadian. Since we're a little bit tight for time, and I could spend the entire session telling you about our distinguished speakers, with their permission, I'm just going to give you a brief introduction, and I think you can read more about them in your printed booklets. After I introduce our speakers, we're going to hear from each of them one by one up here. Nobody is going to trip when they come up here, hopefully. And then we're going to save some time for your questions. And if you don't have any questions, I sure do. We've got 2 professors, and then we have 2 excellent in-house attorneys. Now, if any IP scholar needs no introduction, it's our distinguished guest, J. Thomas McCarthy. His treatise, McCarthy on Trademarks and Unfair Competition, as you know, has been cited in more than 6,000 USPTO and federal opinions, including 12 U.S. Supreme Court opinions. We are all indeed fortunate that throughout his illustrious career, Professor McCarthy has chosen to devote his wisdom, scholarship, and writing clarity to help us better understand trademarks and its importance. So thank you, Professor McCarthy. Next to Professor McCarthy, we have Professor Mark McKenna, who teaches and writes in the areas of intellectual property and privacy law at Notre Dame Law School. Oh, sorry. Okay, I'll get to something else afterwards. I've got a special treat for you. Um, and Professor McKenna is widely recognized also as a leading IP scholar, having published in many of the most prestigious journals in his field. And his most recent work is focused on the intersection of IP rights regimes and the intersection of IP rights with adjacent rights. So now let's move on to our in-house attorneys. Beside Professor McKenna is Rick McMurtry. And Rick is the Senior Vice President and Associate General Counsel with Turner in Atlanta. But you'll notice he has a strong Nashville accent. At Turner, Rick and his team are responsible for legal matters relating to trademarks, patents, anti-piracy licensing, advertising compliance, and IP enforcement for more than 100 media properties worldwide, including CNN, TNT, Cartoon Network, The Bleacher Report, and many others. And Rick is also the head of the Turner Music Group. I'm amazed that with all of that, you were able to join us today. Equally busy is my friend and colleague, Makalika Nahaloaha. And Makalika is the senior attorney at Microsoft, and she leads the entire trademark group at Microsoft. And I don't know how many brands and trademarks that is, but it's a lot. And her team manages all of the trademark clearance, counseling, rights procurement, and portfolio management work. In addition, Makalika has taught law and the arts as an adjunct professor at Seattle University. So now, before we get started, my little special treat is that I wanted to find out a little bit more about our speakers and what do they do when they're not working, or what's something about them that maybe we don't all know. And so we'll start with Professor McCarthy. He is a watercolor painter. I would have asked you to bring some samples of your work, but maybe we can find that online. Professor McKenna, and this is what got me thinking about these things when I made the introduction, I learned last night was a walk-on quarterback at Notre Dame University. So that's pretty impressive and very timely with it being Super Bowl weekend. Now, Rick McMurtry is equally talented in different areas, and Jeannie, you'll like this. Rick is an excellent karaoke singer. And so maybe we can have him come out to the karaoke events. Now, Makalika has a lot of talents, but what interests me is that she loves animals and has a lot of pets, including an iguana, a couple of dogs, a cat, and a hamster. And I think you should spend time with my husband, because my husband is forbidding any animals in our house other than our kids. And in my spare time, I like to play tennis, hike, and I'm a hockey mom. So I don't have the same talents as some of these folks, but it's always nice to learn a little bit about each other. So with that, Professor McCarthy, will you start us out? Thank you. Yep.
Good morning. I want to extend my personal welcome to you to the 2019 McCarthy Institute Conference. And I'm going to talk this morning about the Rogers test, because today all courts in the United States will apply some version of what's called the Rogers test. It's a two-step balancing test. It was created by the Second Circuit 30 years ago, so that when a trademark is used in an expressive work, the Rogers test is a method for balancing between the free speech policy of the First Amendment and the Lanham Act policy of preventing deception and confusion. There's two rationales for treating expressive works differently. First, they implicate, of course, the First Amendment right of free speech, and second, as the Ninth Circuit remarked, consumers are less likely to mistake the use of somebody else's mark in expressive work for a sign of association or endorsement. Under the Rogers two-part balancing test, a trademark used in an accused expressive work will be prohibited but only if, first, there is no artistic relevance to the accused work, and second, if there is artistic relevance, but the use of the mark in the accused work explicitly misleads as to the source or content of the work. In the seminal Rogers case 30 years ago, the use of the name of famous actress dancer Ginger Rogers in the film titled Ginger and Fred was held not to be a false endorsement. Under Lanham Act 43A, the court determined that Ginger Rogers' name had some artistic relevance to the content of the film, and the title was not explicitly misleading. Federico Fellini's film, Ginger and Fred, starred well-known Italian actors Giulietto Massina and Marcello Mastroianni. It was not about Fred Astaire and Ginger Rogers. Oh. Thank you. Yes, there they are. Doing the two-step. It was a satire built around a kind of bittersweet reunion of the two retired cabaret dancers who were once known by the nickname Ginger and Fred because, of course, they imitated America's dancing legends. Now, the Rogers test applies only to expressive works, not something that qualifies as an advertisement for something other than that expressive work. For example, use of a mark in an advertisement for clothing or cell phones is clearly not an expressive work. But the expressive work category is a very big tent, and it covers everything from entertainment, motion pictures, to comic books, to video games. In the Empire case, the Ninth Circuit narrowed the trademark owner's rights by stretching the free speech defense to include advertising and promotion for the expressive work. That is, if the title and content of an expressive work, like a television series, is protected, so also protected is its advertising. The court said there was no infringement of the mark Empire, which was used for the plaintiff's hip-hop, rap, and R&B music publishing company by use in advertising and promotion for Fox's Empire television series, which portrays a fictional hip-hop music label named Empire Enterprises. The court said it was, quote, only a minimal logical extension to extend Rogers' privilege from the title and content of a work to include advertising for that work. In effect, the court said that advertising shares in the free speech privilege of the expressive work itself. The Rogers test can create a significant benefit for the producer of an expressive work sued for infringement. Courts have held that a trademark infringement claim in these cases can be dismissed under the Rogers rule at an early stage by a motion for summary judgment or even a Rule 12b6 motion to dismiss for failure to state a claim. This opens an opportunity for the defendant to get a quick and less costly disposal of an infringement lawsuit or perhaps a quick settlement. In addition, the Ninth Circuit in the Honey Badger case last year dealt some high-value procedural cards to defendants in these cases because the court held that if the defendant makes a, quote, threshold legal showing that the accused work is part of an expressive work protected by the First Amendment, at that point, it is the plaintiff's burden to prove that it can meet one of the prongs of the Rogers test. And of course, even if it can do that, the plaintiff still must go on to prove traditional likelihood of confusion to win a case. And that raises the question, what do you mean artistic relevance? How much is sufficient? One thing we do not want is for judges to be in the position of having to make the literary, artistic, and creative decisions of how much artistic relevance is sufficient. What we're talking about is this balance between free speech and preventing confusion. So that's why most courts today say that all that's needed is that the level of relevance merely be above 0. This is a yes or no rule. There should be no room for a judge to make an artistic evaluation of how important the use of a trademark is in the defendant's work. Here's a hypothetical. Your client has created a video game in which the players, right here in New York City, fighting to save the world from a rampaging robot monster who is destroying everything in its path. In a scene set in Times Square, the monster is ripping up the place and tears to pieces a big McDonald's Golden Arches sign. You get a cease and desist letter from McDonald's saying that this violent and bloody game is an infringement, and they're concerned because it's inconsistent with the family-friendly image, and they demand that that episode be deleted from the video game. Your client's designers say, well, all we wanted was for the scene in Times Square to be as realistic as possible. The McDonald's sign is there in the real world, just the same as is in our video game. Well, is this eligible for a Rogers privilege? Of course, I think everyone agrees. There's no doubt that a video game qualifies as an expressive work within the First Amendment. The Supreme Court said so in its 2011 Brown decision. But is creation of realism a valid basis for artistic relevance? And the answer is, if courts outside the Ninth Circuit follow the Virag case, then the answer is yes, it is a basis for artistic relevance. In the Virag case, the Ninth Circuit affirmed dismissal of an infringement claim brought by the Italian owner of the Virag mark for floor products. Complaint alleged infringement by the defendant, Sony's use of the mark in its Gran Turismo auto racing video game. The accused video game was located in the real-life venue, the famous Monza Formula One Italian Grand Prix, and at the real Monza track, a bridge over the track, prominently displays the Virag trademark, and so did Sony's video racing game. This use had artistic relevance, said the Ninth Circuit, because, quote, a legitimate artistic goal is realism. So the plaintiff's claim was dismissed with prejudice on a Rule 12b-6 motion early in the case. Artistic relevance also stretches to include parody. Judge Hellerstein here in the Southern District held that Who's Holiday, a stage play parody of Dr. Seuss' book, How the Grinch Stole Christmas, was not a trademark infringement, citing the Rogers precedent. He also held it was not a copyright infringement. Is something more required? In some district courts at one time said, to have artistic relevance, the accused work must specifically refer to the plaintiff's mark. For example, Judge Patel in San Francisco said at one time that not only must the use refer to the plaintiff, but in addition, the plaintiff's mark, quote, must be of such cultural significance that it has become an integral part of the public's vocabulary. Well, of course, this view considerably narrowed the scope of the Rogers privilege. And obviously, in a case like the Empire case, the accused mark did not refer to the plaintiff's company at all. It referred to the show setting here in New York, the Empire State, and the subject matter of the music and entertainment conglomerate in the TV show, Empire Enterprises, a figurative empire. Lower court in Empire said that's enough for artistic relevance. In the Los Angeles District Court said that the accused mark does not need cultural significance, does not need to specifically refer to the plaintiff at all, so the Rogers privilege applied. The second prong of the Rogers test requires that the plaintiff prove that the use of the mark in the accused work explicitly misleads. And I think the use of this modifier word explicitly means that to defeat the free speech defense, the deception or confusion has to be relatively obvious and expressed, not subtle or implied. Explicitly mislead requires something more than creating the kind of likely confusion that would trigger a traditional trademark infringement claim. The Second Circuit here in New York said that explicitly misleads means that the confusion must be, quote, particularly compelling. I'm not sure what that means, but it appears to be a more exacting version of the ordinary likelihood of confusion standard. The Ninth Circuit takes a different view. The Ninth Circuit has warned that the explicitly misleads is not the same as likelihood of confusion, and the court in the Empire case said that what you should look at is what the defendant has done. The defendant must make overt claims or explicit references to the senior user. And Mark McKenna will have some interesting things to say about this Rogers second prong. Well, this was a quick overview of how the Rogers test works. It's a potent legal tool for defendants, and at least in the Ninth Circuit, is difficult for the plaintiff to overcome. I see and characterize the Rogers test as a kind of privilege asserted by the defendant for a producer of an expressive work. And it certainly can be a powerful tool for a defendant against claims of trademark infringement. Thank you. Thank you.
Okay, so, I think, where's the clicker at? There it is, okay. So let me just start by thanking Barton and Jeannie and David and Janice for including me. It's both an honor and a sort of daunting task to follow Tom McCarthy at the McCarthy Institute, especially since I've learned so much over my career from Tom and from his work. I think it's also worth just saying, and many of you probably had this personal experience, how gracious Tom has always been to me and to many others in our field. It's really not an exaggeration to say that Tom is largely responsible for making trademark law a serious academic topic. People didn't get hired to teach trademark law at American law schools 20 years ago, with one or two notable exceptions. And he made it a field that now is sort of robust, and there's a whole bunch of us that we get to go around and do this. So we all owe you a debt of gratitude for that, Tom. I appreciate it. So Tom's done a characteristically wonderful job explaining the state of the law with respect to use of marks in expressive works. I agree with virtually everything he said, so I'm just going to try to add a couple of things here. And the first thing I'm going to do is I'm just going to try to revisit for a minute some particular features of the Rogers case itself that I think sometimes get underplayed and sometimes parties try to mischaracterize in cases. And I'm going to do that in part because I think it might help us think a little bit about some of the ways the newer cases challenge the Rogers framework. And then second, assuming I don't run out of time, I just want to talk for a minute about the relationship between Rogers and the Supreme Court's decision in Daystar, which may be becoming more relevant in some of these cases as at least the Rogers framework gets tested. Okay, so let me start by saying, Tom showed you this before, so Rogers, as almost all of you probably know, is about this movie that's entitled Ginger and Fred. The dancers in the movie are not Ginger and Fred. They are these other characters who become known as Ginger and Fred because they want to become professional dancers like that. So it is not a biographical use. It's just a sort of referential use about these characters. But the first thing just to say about that is that Rogers is about titles, right? And I mean that in the sense that it is about titles sort of thoroughgoingly, right? The one thing the court says at the beginning is that titles, like artistic works, they identify are of a hybrid nature, meaning they're kind of like trademarks because they kind of identify something about where the movie comes from, but they also have this sort of artistic relevance. They're hybrid, right, in that sense, right? Consumers then have a sort of hybrid interest in the use of titles because they sort of rely on them like trademarks, but they also sort of rely on them as informational devices about the works. And then the court develops this test, which is all about titles, right? So I say that because sometimes parties have tried to use the fact that it's about titles to argue that the Rogers framework shouldn't apply to use of marks within the content of the work itself, right? Cases like this is a case called the University of Alabama Board of Trustees versus New Life Art, where the artist, Daniel Moore, was painting pictures of University of Alabama football games, and the university argued that the use of the uniforms there violated its trade dress rights, and tried to argue to the 11th Circuit, Rogers doesn't apply because it's not a case about titles, right? It's just within the content of the work, right? So from at least my perspective, fortunately, courts have almost always rejected that. In this case itself, the 11th Circuit rejected it. The 9th Circuit has repeatedly rejected that argument, and in the Mattel cases, Walking Mountain, and the MCA case, which is the Barbie girl case, in ESS versus Rockstar, over and over again, courts are pretty clear. It doesn't just apply to titles. I think just the important thing to note, though, is that the argument that Rogers is only about titles and shouldn't apply to uses within a work gets Rogers almost exactly backwards, right? Rogers is all about titles because the court treated titles like quasi-trademarks as special in the sense that they were, like trademarks, relied on consumers in a particular way, right? But notice that the case doesn't involve just the use of Ginger Rogers' name in the title. The movie was about dancers who became known as Fred and Ginger, right? So the use of Ginger wasn't only in the title. It was throughout the content of the work. And notably, the court didn't even entertain any sort of argument that the use of her name within the film was actionable in any way, right? And I don't even believe Rogers argued that in the case. It was entirely about the title because titles were sort of special in raising trademark concerns, right? Oops. So I'm losing track of my notes here. Sorry, I froze for a second. Okay. The second thing that I'll mention about Rogers itself is that the reference to Ginger Rogers, as Tom was describing before, was referential but not biographical, right? The movie wasn't about Ginger Rogers. The character in the fictional movies was referred to that way because she was a dancer, right? And here again, this is another circumstance where parties have sometimes tried to mischaracterize Rogers by trying to argue that it only applies when the work is directly about the person or the mark referred to. So Rosa Parks argued that in her case that about the Outkast song, and which I think was the only case, at least prior to Gordon versus Drape, where a court ever questioned if the use was artistically relevant, right? And basically sort of accepting that kind of argument. But clearly Rogers itself didn't require that level of relevance, right? And I mention that because I think those features have some bearing on the evolution of Rogers. So let me just take Empire, for example, the case that Tom talked about for a little while. So there's a couple of things going on in that case, most of which Tom already talked about. So one is the defendant's use artistically relevant, right? Well, Empire argued in that case for a requirement that the junior work has to refer to the senior work, and that the Empire show failed that test because its use of the word Empire didn't refer to Empire distribution, right? Which is to say, Empire argued that Rogers is really just a special instance of nominative fair use, right? And that the reference has to be to the mark owner, right? Or Rogers doesn't apply. And the court rejects that and says, well, reference to a work may be a component of artistic relevance. It's not a threshold requirement. It's not a prerequisite, right? And I think that matters because it recognizes that use of a mark can be artistically relevant because it is referential, like Rogers, but referential need not mean biographical. It also means that a use might be insulated by Rogers when it's not referential at all, right? Artistic relevance is judged simply by evaluating the relationship between the use of the mark and the work. It doesn't necessarily, at least, entail external reference to the mark owner at all. And that's, in my view, at least a good result, but it does make Rogers harder edged and more like a rule for uses in expressive works, and you might characterize it as an expansion of the Rogers rule, right? In that it might insulate not just references to the mark owner, but uses of things that happen to correspond to that mark, but actually aren't uses of that mark at all, right? They're just references to something that happen to be the same word, right? The other thing I think that Tom mentioned that makes Empire a harder case is this question about the ancillary uses, right? So it's not just that Fox titled the television show Empire, but also that it has all this sort of merchandise and promotional uses, right? And the Ninth Circuit insulates those uses too, as Tom described, basically saying those are also shielded by Rogers. And again, I think that's the right result. But in a world where the boundaries are blurring between content itself and associated content or promotional activities, this is probably a question that's going to keep arising and one that's going to keep pushing on Rogers. It's also likely to create some real conflict in cases like Empire, since the promotional activities were actually quite close to the core activities of the plaintiff, right, which was a label. Okay, so let me just talk for a few minutes about Gordon versus Drape. Okay, for 1 minute, I'll talk about Gordon versus Drape. I'll try to do that fast. So those of you who don't know, I'll apologize in advance for the language I'm about to put up here, but if you know the Honey Badger video, that you should watch it. I won't play it for you, especially since I'm running out of time. So what the defendant does in this case is create these greeting cards where it puts this honey badger on there, right? And then the inside of it repeats something close to the punchline. The punchline of the video is honey badger don't care, and then variations of it. The cards are a little bit more graphic, right? There's a whole bunch of these. It's your birthday, right? Honey badger don't care about that. But it turns out in the Ninth Circuit, honey badger does care at least a little bit, because what the Ninth Circuit did is, in its original opinion, it basically says artistic relevance requires some determination not just of whether it's relevant to your artistic work, but whether you also add your own artistic expression to the work, so that you can't just sort of copy the mark in, right, and then call that artistic relevance. And then the Ninth Circuit it was suggested to the Ninth Circuit by a number of people, including some of us, who wrote an amicus brief, that was probably not a very well thought out opinion. So it gave it a revised opinion in which it just said, you're right, we shouldn't have said that's about artistic relevance. It's really just about whether it's explicitly misleading, but repeating the same thing, that in order for it to have to be not explicitly misleading, it needed to have minimal artistic expression of its own, right? And I think that's really what's sort of an introduction of a transformativeness test, which is new, and I think probably not a very good development. At the minimum, what it does is it, I think, undermines the point Tom made about not wanting judges to have to make judgments about art, because it introduces that necessarily into the equation. So maybe I'll just wait until we have questions and I'll say something about Daystar, but I'll just very sort of quick punchline about it to say, many of you probably think about Daystar as a case about the relationship between trademark and copyright, and so you might think it has nothing to do with what's going on here. But given that the resolution of that case is really just a matter of statutory interpretation, where the court says, the Lanham Act doesn't give you claims where the nature of the argument is confusion about the origin of content, as opposed to physical goods, there's actually quite a lot of overlap, I think, between Daystar and Rogers. And insofar as Rogers becomes unstable, we may be likely to see Daystar sort of take on a bigger role. So I'll stop there. Thanks. I'm just going to go ahead.
All right, so I'm equally intimidated. We've just added from Professor McCarthy another professor. So I am not going to talk about case law analysis because that is not my lane here. My lane here is talk about being an in-house attorney and the application of Rogers v. Grimaldi as both a content creator and a content owner. So I'm going to talk a lot about the practical, not a lot, I'm talking about 9 minutes, about the practical considerations that we take into account. I think Rogers v. Grimaldi gives content creators a pretty wide berth for use of trademarks in their artistic works. But just because you can do something doesn't necessarily mean you should do something. And some of the things that we think about when using trademarks in artistic works is the business considerations. What is this mark? Is it an advertiser's mark, a potential advertiser's mark, a competitor's mark? Or could we get paid for use of this mark in this content? Maybe that's something we should think about before we just throw something in there in the content. If I've got an advertiser and they are a big advertiser on our properties, maybe they don't like being used in your content. And maybe that means you should not use their mark because they might pull their advertising dollars. Or maybe they'd very much like to be in there and not like their competitor to be in there. I see my friend Joe Ferretti sitting right there from Pepsi, and maybe if I put a Pepsi can in my content and Coke is a major sponsor of my network, they're not going to like that. So we do have to think about those things when placing our marks. Do I have any fans of Adult Swim in the audience at all? Anybody? Does anybody know this show? This Rick and Morty. That's right. This is Rick and Morty, and this is a pretty famous episode of Rick and Morty. Do you know what this episode's about? No. Oh. Anybody else? Does anybody know this one? Yes, it's about Szechuan sauce. You're exactly right. This is Rick and Morty. Rick and Morty go back in time to McDonald's because they love Szechuan sauce. And McDonald's doesn't sell Szechuan sauce anymore. It was used as a promotional campaign for the movie Mulan, Disney's movie Mulan, back in 1996, I think it was. And so they travel back in time to get their beloved Szechuan sauce. As a result, guess what happened? There was a demand for Szechuan sauce, the real thing, at McDonald's. It led to consumer demand this is the heights of it. They brought back the sauce. McDonald's brought back the sauce after consumer demand in very limited supply. That led to fans camping out overnight. Overnight, this is pictures of people lined up for Szechuan sauce. They drew lottery numbers to be able to get their Szechuan sauce. McDonald's ran out in one day out of Szechuan sauce. There were riots in the street that they didn't get their Szechuan sauce. In fact, one package of Szechuan sauce on eBay sold for, does anybody have a guess how much a pack of Szechuan sauce would sell on eBay? Come on.
Too much.
Keep going. More. More than 10. No, don't get crazy. $14,000 for a pack of Szechuan sauce. And did Rick and Morty get one penny of that $14,000? No. No. But McDonald's called it their most successful social media campaign in McDonald's history. Wow. So think about that next time you're putting McDonald's, and we're picking on McDonald's today. I didn't realize that we both had that, but when in placing of your content, placing McDonald's in your content. I'm gonna see if I can play, I haven't tried this trickiness yet, this clip from Adam Ruins Everything, which is a true TV show. How do I do that, Janice? Do you know? I didn't test that part of it. I can't. All right, I'll act it out.
Sing it.
Yeah, I'll sing it for you, my karaoke skills. So in this show, Adam Ruins Everything is a show where Adam kind of tells you the real truth behind certain things. And they're talking about men's products and women's products that are essentially the same thing, and yet the women's product costs much more. And in this, they're showing some razor blades. And when he shows the razor blades, what he flashes up are generic razor blades. You can't tell. They're not branded in any way. One's in a blue box, one's in a pink box. It may look like Gillette. But you don't have anything in there. And he's really talking about the fact that these two products are essentially the same, and yet one costs much more. Guess who's advertisers on our networks? Those very product owners who sell razor blades, both the men's and the women's. So we probably don't want to go into great detail to disparage the women's razor blade market to talk about that. And yet at the same time, in the same episode, he talks about other branded products and goes into more detail about them. And that requires him to talk about the actual product itself. When you're just making a sweeping reference to say, like, this men's razor blades are less expensive than women's razor blades, and you want to hold up a product, you can do that. You better make sure it is, in fact, the more expensive brand. But without going into more detail around that, you're running a risk of sort of upsetting your advertiser in some way. But if you're using specific brands and you do use a little detail, then we feel a little more comfortable with you doing that, purely from a business perspective. All right, so that was my great rendition of Adam Ruins Everything. Both Professor McKenna and McCarthy talked about the Empire case. I find that case fascinating because it didn't refer back to the actual Empire distribution records, the senior mark user. And it is, in fact, about a record company. And guess what you're very likely going to have if you have a hit show? Some merchandise that goes around it. And if it's about a record company, what do you think you might have? Music. You might have some records with that. And then you're branding the records with Empire. There's a competing Empire brand out there. And you have to question whether that's going to limit your ability to merchandise your successful product. And so when you're doing the clearance, even when you think about Rogers v. Grimaldi, I think you still have to think about that merchandise and whether that merchandise could lead to some confusion with the senior mark. But we're talking about virtual reality, which I was stretching to think about, like, what can I do? We have one virtual reality product right now, and that is Rick and Morty for Adult Swim. It's kind of, I got to go to the Adult Swim offices and play it, and it was super cool. Before it came out, I felt like such a, avant-garde guy. And so we have Rick and Morty, and Rick and Morty is very fantastical. It's this universe that's called the multiverse. So I would argue that just about anything is artistically relevant in Rick and Morty because it's such a fanciful world. Unlike Grand Theft Auto, which is supposed to be set in a real life setting in downtown LA or something like that. And this use right here is not, Grand Theft Auto did not use Rick and Morty. But this was, what did they call this? I had a note. It's called a game mod. It's a modification of a game where a fan actually created this. And but if Grand Theft Auto all of a sudden wanted to use Rick and Morty and throw them into their game, I would say that is explicitly misleading. I mean, there's no artistic relevance to having Rick and Morty there. They're not in downtown LA. And Rick and Morty, guess what? They do have their own video games, and they do appear in other works. And so I think it would be confusing to put them. But if Rick and Morty wanted to be playing Grand Theft Auto, I think they could do that and use the Grand Theft. Isn't that convenient for me? I can use yours, but you cannot use mine. But I think that's fair. And then last, I'd still question if you're in a virtual world, whether you run some greater risk of tarnishment. And this was Professor McCarthy's example of the giant robot taking the McDonald's logo and ripping it to pieces. And I thought about that Dickie Roberts case where, I don't know if you guys know this case, but David Spade, it was a child star and he never really got his childhood. And so he wanted to relive it. So he gets on a slip and slide, but he forgets to put water on it. And he goes spinning down the slip and slide and just rips the hair off his chest, and he's all red chested. And the Whammo, the makers of Slip and Slide, were not in love with that use, and they believed it tarnished the mark. And the court said, no, it's so ham-fisted that nobody's legitimately going to believe that your use of Slip and Slide in this manner really disparages the mark in any way. And yet, I wonder, in a virtual world where you can do just about anything with things that are on there, whether there is a greater risk of tarnishment. I don't know the answer. You can ask the professors that question, but I think that it bears a greater risk. And then the last thing I'll say is live by the golden rule. We are content creators and content owners. So just because I said, you know, I can do it to your mark, but you can't do it to mine, I do try to live by that rule. We live in a glass house, and so we do try to think about that as content creators, that, you know, we are trademark owners as well and need to be conscientious of that fact.
Thanks,
That's what I
Ruth.
got.
Thank you. Right.
Okay. And how would I control the slides? Oh, here we go. Okay. Good morning. So, actually, I'm so grateful, Russ, that you called out that we have so many students in the room, because as I was preparing for this, even though I've come for the last, I think, 5 years, I forget, and I'm actually so excited that we've got 45 students. So, I'm going to actually try to recalibrate a little bit and think about how to really target comments that are going to speak to you guys as well, because I think this is great, and I get really excited about students. So I've agreed with what's been said so far, and what I'm going to try to offer is some perspective on how this impacts Microsoft, what Microsoft's experiences have been. One way that you could think about the difference between me and what I'm going to present from Microsoft's role and Turner's is, you know, thinking about how this applies in more of a gaming context versus a film kind of entertainment context, like a video context. So this slide was really intended to tell you that, you know, you can trust that I have something valuable to say because Microsoft's a big company and makes a lot of money doing this work. But you know, more seriously, we do actually hold a pretty, I feel lucky working for Microsoft because we hold multiple roles in this ecosystem. We are also a brand owner. Really lucky to have one of the most highly valued brands in the industry. We're a platform provider, and so when you think about our Xbox and our Xbox Live and our Mixer platforms, you know, that part of our business really depends on ensuring that we have the right context for a thriving creation of creative works in the gaming space. And then, of course, we're also increasingly becoming a first-party publisher of the content and currently have 13 different studios that produce some of the most widely recognized games in the world. So we're looking at it from all of those angles. And so what I kind of wanted to add is to say, look, I think that Rogers is good. Like, I think Rogers, or something like Rogers, the industry is begging for it, and I wanted to share that from a gaming perspective. I want to go actually from two different altitudes. One, talking at the high level about why, from a policy perspective, I think this is right, and why I think, you know, while I'm not, there might be improvements on what Rogers' specific articulation looks like, and the courts are sort of teasing this out through the cases that have come after it. I think in principle, the notion that we have this is the right result given the way that our country thinks about the balance of interest between our want, desire to encourage creative works, how much we value freedom of expression, and at the same time want to ensure that, you know, consumers are protected. So when you think about the value of all three of those goals versus coming from an entrenched trademark-focused goal, I actually think from a policy perspective, we're at the right place. And I think that also, if you didn't have something like this, what the result is actually super challenging if you equally value creative expression and believe that we should be encouraging creative works. So I want to talk a little bit at that altitude. And then I also want to contribute some of the more practical issues when you implement it, which hopefully will speak to everyone in the room, but I think will probably be enlightening for students who don't probably get that in the day-to-day. So first, sort of in defense that we need this, that, you know, games are a part of the creative work that we want to encourage. So a little bit about the industry. Gaming content is some of the fastest growing, it is the fastest growing segment of entertainment content in terms of what's being consumed. So we're living in an age where we're breaking records every year with how much content is being consumed, and gaming is growing very quickly. And so not only is there an economic advantage, and it's creating a lot of good work, it's creating a lot of great expression, but I would also say that it is fulfilling a virtuous thing in terms of what the public benefit. beyond just looking at the economic. And I felt the need to frame it that way because I think as one, some of the emerging interesting work in this area of law is looking at gaming. And I think some of the things, when you think about how do you look around the corner at what's coming, it's going to present itself in gaming versus in traditional video content. And so I know we're coming in from a context at which, depending on a little bit of a generational issue, there's a little bit of a skepticism as to what how much we are trying to encourage gaming when we think about our country's policy and history of wanting to encourage creative works. And so I wanted to just kind of share a comment from Phil Spencer. He is the Executive Vice President of the Gaming Division for Microsoft. And I think his comments on what gaming does for us as a public from a speech he gave last year just hit home for me. He said, "I believe gaming is one of the most important art forms this planet has. It's interactive, it brings people together, we cooperate together, we have good competition together. It's a level playing field for people of all abilities for the most part. And it can be a space that in a world where we have way too many things that drive us apart, gaming can bring people together." So that's my plug for, when you think about the gaming industry and the pressure that the gaming industry is actually putting on this test and on this system, there is a good reason for why we want to encourage it, and it's not just a fight between content creators and brand owners. Is that actually, just like we have historically thought about creative works, gaming is actually beneficial to our society and right in line with what the founders wanted us to promote when they talked about the useful arts.
Except that my son won't do any of his homework because he's only on his Xbox.
Well, I'm glad to hear it's an Xbox. So then as you think about what is the gaming industry focused on? So we're focusing on enabling global participation. We're thinking about that in a multitude of ways. We're thinking about how to be inclusive, how to be accessible, how to help get to people with all different kinds of access to IT infrastructure. But we are also thinking very key is world building, right? And so these are just some graphics of some of our most popular franchises. And what each of these has in common is that as technology has allowed it, we've created more complex, immersive worlds, and we're going to continue to do that. And that is super key to allow people to frankly play, right? This competition, this play that is so important that psychology is showing us is actually very important to building great social bonds and personal health. Like we are trying to meet that need by providing really immersive worlds. And so with that, I think that what is exciting about the V-Rig case is that it's recognizing that realism is an important aspect of creating these great worlds. And I will just say that from our experience, I completely agree, right? And so the experience of our gamers is that that's super important. And so I think, that's another case that is going in the right direction in terms of thinking about how are we going to strike that balance between brand owners and creative expression. Okay. So when we think about that, that context, that need for us to create immersive worlds because we want to encourage this kind of creativity, it begs for a Rogers test, or at least a Rogers-like approach. And I think when you look at the experience of our gamers, what's interesting is that they actually, when we look at the cases and actually our own experience with the gamers, because this is a part of the world building and the experience that they expect us to provide them, I think the courts are actually getting it right, that if not for actually the fact that we fight about these issues so much, they are often not confused. And what I thought was interesting about some of the cases that have involved battles around this is that one of what has come up more than once is courts saying, people expect that you guys are licensing this content. So they're not saying, I'm in this experience and I'm confused. They're saying that their confusion is actually caused by the fact that these are actually quite public disputes that we're all having about this stuff. And in fact, when you look at these gamers, what is becoming increasingly true is that they're content creators themselves, by the way. So millions of hours of content is consumed every year of people filming or capturing their own gameplay, and then a lot of people who don't actually play games themselves are consuming hundreds of hours of content a year of other people's gameplay. So that's another facet to what this area of industry is providing in terms of creative expression. And so they're also constantly being tangled up into what they can do and they can't do. And so it's actually our activity as a legal system that is creating this expectation of licensing and creating confusion when maybe we haven't. So that's another thing that I'll just add that I don't know is quite obvious to people, is that actually we're trying to, on principle, talk about how do we make sure that we're not confusing gamers. They're actually increasingly super sophisticated. They're content creators themselves, and what is creating the expectation of licensing is our disputes, not their experience as consumers of the content. So how many warnings do I have, Janet? Like 2 of 1. Okay, so then that's sort of high altitude stuff about like what I think the experience is and sort of policy stuff. So then just applying the Rogers test, some things that I'll invite you guys to think about as we go into the questions section is, okay, what are the practical, like how do you deal with this in real life? And so what I'll say for us is, first of all, it has been helpful to have this change in the law. So it used to be, especially in the days when you shipped games, you shipped them in physical product. We're now moving actually to an increasing amount of games being offered in the cloud. But when you're shipping physical product, you really are going to take a probably conservative view on what kind of risk you're going to take. And so before you had Rogers and the cases that later applied it in the gaming industry, what that would mean is that if you didn't license it, rather than take on the risk of having to pull product off shelves, you would just do something different, right? So you'd either license or you wouldn't use it. And what that means is that there's forms of creative expression that didn't happen. And another thing that I wanted to address is that people often will think, okay, well, if you want it, just pay for it. Just get a license, right? Like, what's the big deal? Microsoft made $10 billion in our gaming segment last year. So I don't expect people to have bleeding hearts for, our ability to pay for a license. But I will say that often when people are talking about this, they're sort of importing their views that they apply in the copyright context. And what makes copyright and trademark really different, and again, sorry, kind of targeting the students in the room, is that trademarks are a part of your identity, right? They represent you, they're a source identifier. On the one hand, that might cut towards saying, yeah, and so it's really important that you get my permission before you use it. But at the same time, if you value the ability to produce these creative works, you have to realize that that makes licensing trademarks actually more difficult. So unless you really are concerned, and you'd rather cut towards, you're concerned about consumer confusion, and so you want to cut towards this content not being out there, then you think about whether or not you're actually going to impose that restriction on the content creator, because it's not just about royalties. When you go into a trademark license agreement, obviously you're going to have quality control as like a big part of that, and that makes these licensing deals more difficult. And so when you think about that, you got to be careful about importing sort of that, well, why don't you just pay for the license kind of thing. So you got to think, okay, if that's a hurdle that might not just be about money, and so that might mean that we can't actually provide the content in that manner, and are we okay with the fact that some creative content just won't be out there, because if that's the rule, it's not going to happen. And then the other thing I would say, and I'll just leave this as maybe just teasers for you guys to ask in questions since I'm out of time, is, okay, we've got some clarity in the courts about what's allowed without licensing, but actually, when you're counseling these gaming clients and they're talking about all the different scenarios, there's still a lot of ambiguity, right? And so right now where we seem to have landed is, look, as long as you're not misleading people, which, a lot of experts are thinking, as long as the content isn't playable, if it's background, if it's about realism, then you're okay. And if it's not, then, if it's something that you're charging people for, you're prominently marketing as a feature of the game, then you should license it. And so that's kind of the way we're bucketing it. But as we grow these immersive worlds, those lines are actually not so clear. So I'll leave it there, and if you guys are interested, ask questions about it.
Well, thank you. This was so informative, and I apologize for cutting some of you off, but I really wanted to save some time for some questions and answers. And one question I have as a non-American is, what happens outside of the U.S.? And maybe Rick or Makalika, you can explain if you've had issues outside of the U.S. You must set all of your your internal policies and practices based on the Rogers Rule and the US practice, but I'm sure you've gotten into some hot water or some tricky situations abroad. I don't know if those microphones work. Do you want to?
Hello? Oh, yeah, they're on. So multinational is the default in terms of our distribution. So we always have to think about more than just the US. And one of the practical things that I didn't get a chance to get into, but thanks for asking the question, is how does that impact actually not just the substance, but your ability to, what can you say actually at the end of the day when you're being asked, hey, is this going to be all right, like before we launch something or do something? How much is that going to cost and how long does it take? So this is actually a difficult area for practitioners. You know, in Europe, we need to think about design rights and trademark rights. And I thought, just as an anecdote, I could actually share with you, here's just a clip from an outside counsel that I trust, works with us all the time, and I think is aggressive in trying to get us the best possible results and the fastest and thorough results. But here's just a soundbite from an email on what this would take. It's like, we're going to need to search their design databases of the national PTOs as well as the OHIM or the WIPO. Those normally only produce somewhat incomplete results. They only reflect what is on the register, so they do not capture unregistered designs or possibly copyrighted material or trade dress. In that context, we understand that you want us to conduct a trademarks and design clearance search, but not a copyright review. Is that right? And then they go on to talk about more challenges. So there's all those caveats we start out with in terms of what they can even look at. And then we have another paragraph, which I won't read verbatim, but basically talking about how long it takes to get all of that information and the trade-offs that I'd have to make depending on how they approach the search. And so in the context of an industry that's moving fast, and I'll just be frank with you guys, I think there's a growing respect, and McCarthy's had a big part of importance of trademark. We don't usually get a ton of time to get all this stuff done, right? So this stuff is always going hot. And so I'll say it's a huge challenge, actually, not just substantively to align multinationally, but also there's a lot of logistics, cost, and project management that gets involved in this too. So, you know, again, I don't expect brand owners to have bleeding hearts for us on the content side, but for what it's worth, it's not easy.
Well, and I'll just say the same. Like when we launch a product, we anticipate that it will have multinational distribution. It's pretty easy to throw a signal up and download it anywhere in the world. And outside the U.S., the law is not quite as well developed on this issue, and so we have to be a little bit more conservative in our analysis with anticipation that it could be distributed outside the U.S., where we might just be buying a lawsuit.
David, you've got
Can you hear me? Yeah. Any questions from the audience? I'll wander around here. David Bernstein from Debevoise and Plimpton.
watch out.
Oh, no.
Thanks. So, you know, with Rogers, we started with titles. We've clearly moved to content. And of course, we're seeing the expansion of what kind of works are thought of as expressive, and it's quite clear video games fall into that now. We're also seeing a lot of these right of publicity cases being brought. Here in New York, we had the Lindsay Lohan case that went up to the Court of Appeals, which confusingly is the highest court in our state here in New York. What role do you see for the Rogers test as these right of publicity claims continue to percolate up, especially dealing with expressive works?
Well, so for whatever reason, many courts forget that Rogers was also a right of publicity case. It was both a 43A case and a right of publicity case, and it applied essentially the same test, slightly different words, but essentially the same test. But as you know, David, the right of publicity, the way courts treat expressive works in the right of publicity context is all over the place and across the country. There's, depending on how you count, something like 6 tests that are applied across different circumstances. The one in California, I think, is especially bad. So you have the Ninth Circuit on the same day, same panel, issues and opinions in 2 video game cases that are otherwise factually identical. But one is a 43A claim, and that gets dismissed on Rogers grounds. The other one is a right of publicity case, and that one the court says, oh, no problem, that case gets to go forward. That's not a sustainable situation. I think the Supreme Court's going to have to take cert on one of these cases at some point. If you understand Rogers, as I do, to be a sort of First Amendment avoidance tool, Like at some point, a court that is currently quite interested in the First Amendment is going to get interested in the fact that a lot of these kinds of claims are being made in the context of quite obviously expressive works. So.
Barton Beebe.
Oh, thanks very much. What an incredibly interesting panel. I have two quick questions, one theoretical, one very practical. The theoretical question is just to invite Mark to say a little more about Daystar, because I share the intuition of two of the panelists. One intuition is Daystar is the future, and everything will be sort of litigated around some weird Daystar issue. So how does it work in this context? Also, Makalika's intuition that a lot of this litigation will occur in the virtual context rather than real life. And then the second practical question is invited by the slide. What about the car under Rogers? My understanding is a lot of these game makers get authorization to use the design of the cars, but is that necessary now in light of the way that Rogers has evolved?
Okay, so quickly on Daystar, I'll just say, so Rogers is older than Daystar, right? So a lot of these expressive works cases get framed as Rogers cases because that's kind of the framework courts got used to in thinking about it. But you know, the holding of the Daystar case is that the Lanham Act doesn't give you a cause of action when the argument you're making is about the origin of the creative content itself rather than the physical goods. So that is true of the vast majority of the Rogers cases, right? The argument is that you're going to cause confusion about who's the origin of the content, right? And so you could just as easily frame those cases as Daystar cases, and for the most part, in the sort of majority of the cases, you'd get the same result. So what I was suggesting at the end is, insofar as Rogers is sort of expanding or contracting along different dimensions, the perfect fit of outcome between Rogers and Daystar is going to slip, right? And so we're going to have cases that Rogers maybe doesn't reach under Gordon versus Drape because somehow the court decided they're explicitly misleading, even though it's obviously about the content of the work rather than the physical goods. And so I think we're going to start seeing both of those arguments made in parallel or maybe alongside each other because it's going to be necessary because there's no longer going to be obvious that it doesn't matter that you get the same result either way.
I can take the question about the car. What about the car? So, you know, when you look at the different ways that the courts have looked at the part of the test that's covered explicitly misleading, they've actually been pretty generous and I think with the goal of trying to make sure that even though the test, depending on the court that you ask, is intentionally not trying to be the likelihood of confusion analysis, that still from a practical matter, people aren't confused. And so explicitly misleading has been, there's comments from courts that have said they're not looking just at like express statements, right? So they're looking at the whole context and trying to get the sense of whether or not you're misleading. So again, like query whether in practice it actually is just a likelihood of confusion analysis with different words being used. And so not with this game so much, but in other games where you've got playable content, there's been concerns that when the object that embodies the trademark is actually something that the user must engage with in order to play the game, like driving the car, that signals concern of explicit misleading, that they'd be confused. I'll just have two thoughts about that as you think about where gaming is going. One, I think there's still this gray area, even if you sort of concede that point. What if you're, in this driving game and you're competing against 8 other cars? Can the other cars be the same as the cars that were in the real race? Like, does it matter? Is it because they're moving? I mean, the Virag case, I assume what happens is when you play this game, you actually pass it by really quickly, and I'm guessing that it wasn't very heavily marketed, so, shame on me for not actually looking at that game to find out, but I'm guessing that's the context, right? And so the court's probably saying, pragmatically speaking, like, this is a real quick experience for anyone playing the game, but what if actually the fun of the game is that you get to actually, maybe you can't drive a car that wasn't licensed, but you get to compete against the real cars, right? And so do I have to get licenses for that? I mean, it's just hard. There's a lot of different circumstances in which this can come up, and the cases haven't covered everything, and they've been, I think, reasonably targeted in just deciding one thing at a time, but there's a lot of gray area. Another thing, when you think about the difference between like what's playable and interactive versus not, you know, we're getting into more immersive worlds where actually you just want people to play and hang out. There's not necessarily like a quest you're trying to solve. So when you think about the racing game, you think, okay, well, it's easy. Just they have to play with the car. So any cars they have to engage with, that could be confusing, so you should license those. But what about in a Minecraft kind of situation where you just play? There's no puzzle. You're just playing with stuff. What if you're trying to create a really realistic preschool, and you're just inviting kids, especially with the rise of VR, you're just going to invite kids to play in those spaces. And so you're going to have iconic toys that are in most preschools just laying around, right? So is it interactive? Yes. Do you have to play it? No. Like, is the creative expression a lesser product if it doesn't have that stuff in there? Yes. That cuts towards saying, let people do it. So I think, you know, to your point about my intuition that that's where you're going to see the innovation in the law. It's because of this. It's because of what this is increasingly we're able to offer people, and it's going to introduce novel questions about where the line gets drawn.
Just one quick observation, which is that if that's right, and Rogers starts to falter along the lines of we're going to actually start digging into the necessity of this piece of content in order to evaluate explicit misleadingness. In other words, we're going to make it not about explicit misleadingness, but just about whether this belongs in there. That means Rogers is going to fall away as the way of addressing these cases, and we're going to introduce other things. It's either going to be Daystar or it's going to be full First Amendment evaluation of these kinds of claims. And I'll just suggest that our experience with TAM should give us, as trademark lawyers, pause about inviting the First Amendment fully into trademark law. We should not want that.
Hi, this question is for Professors McCarthy and McKenna. One, do you think the Ninth Circuit went too far in the Empire case in not bifurcating the merchandise versus the expressive works? And two, do you think that the decision would have been different had it been heard in the Second Circuit?
It would have been different if what?
If the Second Circuit decided the case.
Seventh Circuit?
Second.
Second Circuit. The questions make me think that this is a very poor way to make law by taking different Ninth Circuit panels. Yeah. And of course, I think you all know the Ninth Circuit has dozens and dozens of judges, and they do not speak with a single voice. And so we follow as the court zigs and zags, and then to compare the Second Circuit, and sort of like living day by day as the rule changes. This is not a good way to make law. It's not a predictable way to try to build a framework around free speech. And so it puts practitioners in a very difficult situation of having to evaluate how much risk will my client be willing to assume. But I think that's a familiar place that many, especially in-house attorneys and also law firm. I think that the Second Circuit has not had enough experience that we can really make a good prediction about what direction they're heading in. My personal view is judges do not like hard-edge rules. They don't want, and the experience of the Honey Badger case last year teaches me that judges do not want to be pinned down in the future. They don't much care about the difficulty of a practitioner trying to give legal advice, because that's not what judges do. And so they want to keep the framework open for the next case. They want things pliable and open, and that's not what we want. So there's a natural tension there, and you know, if only we had a statutory defense, the same as we have for dilution claims, that make it highly predictable. So we all know what the law is to reduce the costs of legal services, but we don't. And Congress won't do it. They will not do it. because the lobbying interests are too strong. So we are left in this position that we've all been in as law students and lawyers of trying to follow precedent day by day, year by year, and it's different today than it was 5 years ago, entirely different. All the cases I mentioned are very new. So that's the world we have to live in, for better or for worse.
I guess I'll just take your first question about did it go too far. So I think Empire is the hardest of the cases that's been decided recently, and precisely because it isn't just that there were ancillary sort of promotional activities. It's that those ancillary promotional activities were so close to the plaintiff's core goods and services, right? So that makes it a really unusual case in lots of compared to a lot of the other circumstances. I think it would have been hard to imagine the court not saying that promotional goods are covered by the Rogers Rule, because otherwise what you're saying is you're totally fine to create a movie, but you better not advertise it or you better not do anything. And it's hard for me to imagine a court would have said that. And I think probably in the vast majority of other cases that aren't going to involve a record label, that's going to turn out to be an uncontroversial rule. Just happened to be in this case that, you know, that bumps up pretty close against the concern about who the plaintiff was.
But I'll say, that's not merely promotional. That's merchandise for sale. And that's not the same as a movie poster.
Yeah.
And I don't know, as somebody on the media side, then I'd say, absolutely, they got that right. But as somebody who's trying to clear a mark, a title, and I know that there's a potential that it'll be merchandised, it's risky. And to the earlier point, outside the U.S., you know, what are they going to do? Can they? I don't know how popular that show is outside the U.S., but if it became wildly popular in other countries, I think they might have to litigate there too.
I think we're out of time.
Yeah.
So thank you very much. And